Maria slipped on a wet floor in a big box store. No sign, no warning. Hip and wrist injury. Store employee rushed over. Incident report. Ice. Open and shut. 3 weeks later, the claim denied. No record of any hazard. No prior complaints. No footage. And the adjuster already knew that Maria had walked that same aisle earlier in the day without a problem. That wasn't a mistake. That was the playbook. I'm Jason Marker, 25 years fighting for injured people in Illinois. Slip and fall cases are some of the hardest personal injury cases to win. Not because you don't have a case, because the other side already knows how to kill it. And right now, the adjuster who denied Maria's claim is building the file designated to make their fall look like it was her fault. That process started before she even left the store. If you can't prove that the property owner knew about the hazard before you hit the ground, then your case is dead. Full stop. The adjuster already knows this and is betting that you don't. Under the Illinois Premises Liability Act, 740 ILCS 130, property owners own a duty of reasonable care to anyone lawfully on their property. Illinois replaced the old common law distinction between invitees and licensees with a single standard, but notice still survived. You still have to prove that the owner knew about the dangerous condition or that they should have known about it. Two kinds. Actual notice means someone on the property side had direct knowledge. An employee saw the spill. A customer flagged it. A manager was standing 10 feet away. Constructive notice is harder. The hazard existed long enough that any reasonable inspection would have caught it. A puddle from a leaking cooler spreading for 2 hours is different from a spill that formed 90 seconds before you walked in. Illinois courts evaluate constructive notice cases by case. There is no bright line rule. Here's what people miss. The adjuster isn't waiting to review your evidence. The adjuster is already assembling a file to prove that the store never had notice. No employee report, no prior complaints, no maintenance failure. Every gap in your documentation is another brick in the adjuster's wall. Here's what to preserve: timestamp photos of the hazard, the surrounding area, and whether any warning signs were present or absent. While you're icing your injuries and waiting for someone to call you back, the adjuster is building 3 arguments to make your case disappear. First, your awareness. Did you see the wet floor? Were you distracted? Looking at your phone? Were the cones or signs nearby that you might have walked past? Every answer shifts fault onto you. Illinois law follows a modified comparative fault system. If a jury finds you more than 50% responsible for your own injury, then you recover nothing. At 30%, your damages drop by 30%. The adjuster's entire strategy is to push your number up. So Maria's earlier walk through that store aisle, that's exactly the kind of detail that they use to do it. Second, notice. The adjuster will produce maintenance logs showing routine inspections were conducted. A store manager will testify that nobody reported a hazard. They'll argue that the spill was too fresh to detect through ordinary care. They'll get surveillance footage showing the area clean minutes before you fell. They'll use it. If they don't have footage, then they'll use the absence to say that there was nothing to record. If you do nothing else, remember this. Third, causation. Any history of back problems, knee injuries, or hip trouble, and the defense will argue that your injuries predate the fall. They will subpoena your medical records and look for anything that ties to a prior condition. The older the plaintiff, the harder this hits. Here's what to demand: a copy of the incident report, the store's maintenance log for that day, and written confirmation that surveillance footage has been preserved. The evidence that wins your case has an expiration date. Some of it is already disappearing. Surveillance footage, the single most powerful piece of evidence in a slip and fall case, may be overwritten in as little as 24 hours. Some systems hold footage for days, others for weeks, but no store is preserving that footage for you unless someone demands it. Witness memory fades fast. The customer who saw the puddle before you did walks out of the store, and you'll never find them. Employee schedules change. The worker who mopped that minutes too late gets transferred, quits, or forgets. That's Tier 1 evidence, volatile, gone without warning. Tier 2 survives longer. Maintenance logs, inspection schedules, prior complaint records. These typically persist because of retention requirements, business practices, or legal obligations, but they only help if you demand them before they're quietly archived or even overwritten. Here's what you need to memorize: 6 words: report, photos, witnesses, doctor, shoes, silence. Report. Tell a manager immediately and demand a written incident report before you leave that building. Photos. Photograph the hazard, the area, the lighting, the absence of any warning signs. Video if you can. The scene changes within minutes. Witnesses. Get names and phone numbers of anyone who saw the fall or saw the hazard before you did. They leave and they're gone. Doctor. Seek medical attention the same day. Adrenaline masks pain. Hip fractures, compression fractures, torn ligaments. Many serious fall injuries don't announce themselves immediately. A gap between the fall and the treatment is a gap the adjuster will exploit. Shoes. Preserve the footwear and clothing that you were wearing. Do not wash them. The defense may argue that your shoes were inappropriate for the conditions. Silent. Do not post about the fall or your recovery on social media. The adjusters monitor your accounts. A photo of you standing at a family gathering 3 weeks later can undermine months of medical documentation. Report. Photos, witnesses, doctors, shoes, silent. So I want you to confirm this. The incident report was filed. Footage preservation requested in writing. Medical appointment scheduled the same day. What winning actually costs. Now, Maria's case didn't resolve because the fall was obvious. It resolved because we preserved the evidence before the store could bury it. We investigated the property before repairs were made. We subpoenaed the store's internal maintenance and inspection logs. We found a prior complaint about the same area that had never been addressed. And we retained a premises safety expert to testify about what a reasonable property owner should have done. The result was a much larger settlement. That number came from documented economic damages, medical expenses, lost wages, long-term physical consequences, and non-economic damages, including pain and suffering and loss of a normal life. We were prepared to put that case in front of a Cook County jury, and the property owner knew it. They already know. Now you do. One deadline that you can't fix later is the statute of limitations for a premises liability personal injury claim in Illinois, which is 2 years from the date of injury. Under Illinois law, if you miss your case, it is dismissed regardless of your evidence. 2 years sounds generous, but in a case where the strength of your evidence depends on what you documented in those first 48 hours, it isn't. The adjuster is counting on your waiting. Every week that you don't act is a week of evidence that they don't have to fight. Here's what I suggest you do. Get an attorney involved before the evidence clock runs out. The single biggest mistake in a slip and fall case is assuming that the insurance company will treat you fairly. They won't. They're already working against you. If your claim was denied or you're getting resistance from the adjuster, watch my video on what to do when your injury claim gets denied in Illinois. It walks you through exactly how to fight back. If you have a case right now, call Marker Law. We offer a free consultation. We'll tell you where your evidence stands and what needs to happen next. Our number's in the description. I'm Jason Marker. Don't wait for the adjuster to finish building out their file on you. I'll see you in the next video.